Okay. Welcome to Tech Tuesday number 65. And today we're going to talk about an executive perspective on IP and especially education. But first, we're going to take a moment of silence because we are still waiting for 48 hostages to come home. About 5 years ago, I was asked to fill out a survey by Professor Frank Tietze. And the survey was about problems with executives doing clever IP or not. And 5 years later, and just in time, they put out a paper, which I recommend reading. And the title of the paper says it all: The High Cost of Executives' Intellectual Property Blind Spots. And on this slide, I have extracted particular gaps which they pointed out in the paper. They fall into three classes. Class one is missing basics, something basics they need to know. For example, there's different types of IP and different countries treat them differently, and you might need IP in each country. And the perennial not to publish before you file for a patent. The fact that IP has an important role in strategic relationships, like who owns the IP in your relationship, the fact that IP can help you have a relationship. If you have IP, it helps you when you renegotiate the deal. And the last one is that executives fail to leverage IP strategically. How much IP do they need? What do they need it on? Does it match what the company has? Is there any alignment between your IP strategy and business strategy? And yeah, all of these are real issues. And the question is what to do about it. Maria wrote a book on the psychology of IP. And she tries to answer the question from a psychological perspective. Why do CEOs ignore their IP attorneys? So she has all sorts of reasons, including there's no immediate pain, so you can ignore it. My favorite, these are a mixture of hers and mine, the fact that IP is complicated. It makes people just abdicate it all to the expert. They have habits, there's social pressure. They don't expect enough from IP. The worst one in my mind is trusting the IP expert. Should we file a patent? Oh, you decide, you decide. Okay. Basically, I don't want to make IP decisions. And while all of this is true, I asked ChatGPT to check what I really know, which is, do MBA programs have a course on IP? Now think about it. Everybody knows that, 80%, 90% of company value is intangible assets. You would expect them to have at least one course about intangible versus tangible asset using IP, something like that. And most of the MBA programs do not have a dedicated IP course. So you could, of course, take one in the school, but it's not required and it's not listed as, one of the electives. And in the comments on my post, people have agreed that they don't see it. And those MBA programs that do have a dedicated IP course sometimes talk about the law. You can get a patent if it's novel, inventive, and industrial use, but you can't get a patent on a genomically modified mouse in some countries, and you can't get in medical methods in another. Okay, that's the law. That's what we're for, not the executives. Or they talk about litigation. This is what a patent claim is. Here's what's going to happen if you get sued. Here's how you're going to sue people. Here's how you use your patents to sue other people. But of course, most patents don't get to litigation. So when you finish your MBA program, you probably don't know how to answer the question, how do you maintain and leverage your intangible assets? Of course. There's a very interesting book called Understanding by Design. And what this book tries to do is help people plan a pedagogical course. And what they do is they say, instead of starting from the beginning, start from the end. What are you going to have in your test? And now we'll ask, what do you need to teach in order for people to understand well enough in order to do your test and get, good grades? And so the question becomes, what do we need to teach MBAs so that when they get tested in real life, they know how to deal properly with IP, and hopefully the next paper that comes out will be all of the gaps in executive solved, or something like that. So I was thinking about, in general, if I could have a single semester course about IP for executives, what would I have in it? What subject? What issues do I think they need to be familiar with? And of course, they don't need to know IPs, they need to know how to wield IP. And they need to know how to engage with IP experts like me and the rest of you on the call. And of course, I'm not covering all of the issues, all of the subjects, for obvious reasons. So here's what I thought the four basic issues. One is, what is IP about? Two is, where do you meet IP? Three is, how should an executive relate to IP? And four would be all sorts of touch points, situations which an executive might meet. And what do I want to teach about IP, again, at a very, very top level? Well, there's things that you need to know. There's things you need to understand, and I propose a few models, metaphors that might help. There's things you need to experience. You can't learn it otherwise. There's certain skills that you need to develop, and we can't teach them, but we can point you at them. And it's not exactly a skill, it's an issue of sensitivity. It's an awareness that you're surrounded by IP, and your decisions really relate to IP. And how do you learn all of these things? What would be the content of each one of these events? So first of all, there has to be a mixture of theory and examples. A lot of IP should be learned by doing, which means serious games of various types. You have to have stories so that when a similar situation happens to you, you'll say, yeah, I've seen this before. A lot of people who finish the MDA don't immediately go into a position where they have immediate interaction with IP, and definitely not after this point. So you need to consider how you deal with this delay between teaching and practice. There has to be homework, and the homework should probably continue also when you're an executive. Perhaps there needs to be some type of coaching that's where you talk to them, and sparring, that's where you argue with them as they do the job as executives. And the most important thing is developing the habit of not abdicating IP decisions to other people. Each IP decision, each IP situation you get to is a learning experience. Okay, this is all very, very top level. The first subject is what is IP about? And I think this is exactly where the problem starts. What is IP? A lot of people, when they say IP, they think about patents. Really, that's the legalistic way of looking at IP. The issue is not what does the law give me? The issue is intangible assets. And IP, in the broad sense, is intangible assets. If you think about the law, what you get to is, and that's what's called IPR, IP rights. That sounds kind of boring, okay? The law is you can get a patent if it's novel and inventive and industrially applicable. And that doesn't sound like somebody was an executive. That sounds like what he should be giving legal to handle. So guess what? He gives it to legal. People to look at the law as giving him tools in order to wield his intangible assets, he would do it differently. He would say, here's how I want to wield my intangible assets. Legal, can you help me do that? Which is what would be happening. Intangible assets are really special as compared to tangible assets like machines. So a lot of intangible assets are easy to copy. They're very, very portable, not all of them. They're easy to damage, and they can just leak away. The classic statement is that your IP can walk out the door. By the way, I don't like the term IP. I don't like the term intellectual asset for reasons that you'll understand in a few minutes, but I'm limited. Intellectual assets are not well represented in company books. First of all, it's difficult to write them in, but even when you write them in, it's not done properly. We'll see that in a minute. The intellectual assets that you as an executive care about might not be in your hands. Okay, if I have a machine, the machine's in my factory. But if I have a brand like Nike, who owns the brand? You might say Nike. Where is the brand located? The answer is in here. When Ray goes to the store and he sees a Nike shoe and the brand just leaps at him and he just does it, okay? It's happening in May's head, not in Nike factory. Intellectual assets are much more flexible than physical assets. Just to give you an example, you read a newspaper about some sort of scare and you get excited. What just happened? What just happened is that somebody was wielding an intellectual asset, not even this. Some types of intellectual assets need legal support. You have to be able to sue. And of course, that can be legal support can be expensive and slow. But other type of intellectual assets, like trade secrets, is very powerful on its own. F&D Coca-Cola has this wonderful formula, and it keeps it in a safe. Even if there were no legal protections, the competitors would still find it very, very difficult in obtaining that intellectual asset. Intellectual assets are always being created and destroyed, and the question is, does the executive even notice? And the executive has to be able to answer the question, which ones of his assets and which ones of his IP rights are valuable, and how and when is they valuable? The way I think you should be looking at IP is by looking at it as a method of control. What do I want to control? I want to control IP. I want to control activities. In particular, I want to control activities that are not IP. I want to prevent somebody from selling their products. Okay, that's a non-IP activity. I need to control the consequences. Think of uh, companies that allow and companies that do not allow, let's call it fan fiction. Okay, when you take a product and you modify it, and Lego has that, and Barbie from Mattel has that, and some of these companies allow you to do it, and some of these companies like Disney really don't want you to do it. Who are we trying to control? First of all, we're trying to control others, but also competitors and partners and customers. When do we want to control them? A little bit now, but also and especially in the future. And in fact, we want to control activities and others that don't yet exist. There's all sorts of tools that you can use. It can be psychological, it can be practical, it can be by changing the risk calculus completely rational. All sorts of specific ways we're not going to talk about. Controlling IP, I just gave you the example of Coca-Cola's secret formula. Control is not using IP tools. It's true that if you steal the formula, they'll sue you in court under trade secret misappropriation. But the real control has nothing to do with the law and everything to do with non-IP tools. The type of control can be direct and it can be indirect. If we think about indirect, you can shape the landscape so that it's easier to go some places or more difficult to go other places. And your own company should be positioned in view of what the world is shaped like. Now, just to be clear, the purpose of this talk is not to explain how to do any of these. It's the opposite. It's to say, here's things that I believe that executives should be exposed to and be made aware of while they're learning an MBA program. IP creates value, but what's important is that it doesn't only do it as an asset. Okay, IP is an asset. I have a patent, I can sell it. But IP is also a tool. And a lot of the value of intellectual property is related to your ability to wield it. Unfortunately, GAAP, generally accepted accounting principles, which a lot of people follow, do not recognize this type of value as being accountable, and they also don't recognize other value like the positioning of your company. I mean, they do in very general terms, but not specifically. This means that it's difficult for the executive group to talk about these values, and that's why we keep on hearing about intellectual properties and tangible assets, when we in fact should be talking about tools. So one of the things the executive needs to learn is accounting for and actually actively searching for what is the value creation and how does that value tie in to the rest of the company. And of course, once you talk about value, that completely changes the way you treat it in your budget. Now, I'm not sure how many people are aware of the concept of dynamic capability. Basically, and I'm super oversimplifying, it's the ability of the company to dynamically create new abilities and adapt as it needs. So if you think about IP is very dynamic. And if you need more, you can just make more. But IP is more than a dynamic capability. So let's see. A lot of people have a static view of IP, especially executives. IP is my moat, or IP is a licensing source. I have a patent, people are going to pay me money. That's exactly asset-based thinking. Some have a dynamic view of IP. IP is a flexible asset you continuously look at, grab, transform, and it supports your evolving business models. Okay, so that's a more transactional view, which is much better. But you can also have a strategic view where you say, the only thing I care, the main thing I care about with my IP is how does IP make my strategy work and how does it get me to achieve my desired goals? I said before that a lot of IP is not under our direct control. So let's talk about the mind and about law. You can have what you think is an asset, and the law decides that it's not an asset. If you think about legal trade secrets, you didn't protect them properly, legally you don't have an asset. Or you can have a practical trade secret. I'm Coca-Cola, I keep my secret locked in the safe. We mentioned before that the IP can be in the mind. For example, branding. The branding is located in the customer's minds, which of course tells us that marketing is very connected to that type of IP. Sometimes the IP is wielded, sorry for the typo, through the mind. People are scared of patent infringement. Okay, so the way the IP is doing what it's doing is by making people scared. It's happening in people's mind. Sometimes it's in the mind, but not at all in the law. Think about insights. I have a great insight. It's not really protectable by law unless I protect it as a trade secret by not telling anybody. Or it can be in the law, but not in the mind. Some intellectual assets you don't even have to think about, but you still have them. And for example, if I copy somebody else's asset, I don't even have to think about it, but I could still be infringing. And one last and very important thing about law, the law of IP is very political. It's bipartisan, but it's very political. If you consider laws which are clearly in favor of certain types of pharma, think about copyright laws and how some large companies I won't mention got extensions. Think about AI. Right now, there's a big question, and it's a political question. Should you be allowed to infringe or maybe not infringe copyright laws so that your country can have a lead in AI? And you can be sure who's lobbying for and who's lobbying against. Picking up that issue of IP law, I just have here an example of a few issues that don't really have specific tools, but they're very valuable IP, attitude, culture, ideas, insights, I mentioned, problems, data. But even when you do have a law, and that law is relevant, it is usually limited. Okay, trade secrets are much narrower than practical secrets. Inventions is what the inventor does, but what you get protection for is really only specific embodiments. The brand is in the customer's head, but the law is only about, so to speak, trademark. You can get a copyright, but the copyright covers an expression of an idea, not the concept. You can get a design patent, but not something that covers the overall feel, be careful here, of a series of products which you can immediately recognize that they come from the same store. So you have to protect them using trademarks, perhaps, but the design law doesn't help. Some law actually causes damage. When you file a patent, you have to disclose, usually too much. Some law is simply impotent. It's too expensive for you to do it, or you don't know if you'll succeed or get an injunction. That was the first issue, how I think executives should be taught about what IP is. The next question is, where is IP doing, whatever it's doing? The first place, which is often ignored, is the relationship between IP and company structure. So IP definitely affects company structure. And luckily, the executive can often control it. IP also affects the ecosystem structure. And there's papers out there about how IP affects the number of players, the relative sizes of the players, the potential for monopoly, or other ways of the money going to one person and not another. Sometimes the ecosystem does not exist, and then you can create it in your own vision. Sometimes it does, and you need to shape it. At the same time, the company structure and the ecosystem structure suggest problems and opportunities. I'll give you an example. Let's say we have a company whose structure is that a lot of the valuable innovation is open innovation. Well, you have an obvious vulnerability that whatever is developed won't belong exclusively to you. That's an IP vulnerability. Based on the structure of the ecosystem, you can see how powerful IP might be for you or against you. Sometimes IP is less important. It's valuable to know that. Spend less money on your IP. There's also issue of product structure. Okay, you have the whole company, but you also have product lines. And again, the structure of how you make the product and how you use it and how it relates also suggests all sorts of IP issues. So structure is a kind of hardware, but IP flows. And it's created in one place, it's transformed in another, destroyed somewhere else. It's especially true about data, but not only data. You store it somewhere, and most of it is not created or used in the company. And again, data, branding, aftermarket add-ons, all of these are IP which you want to have under your control. They're flowing around, not happening in your company. So one of the things an executive should learn how to do is mapping out what this IP flow looks like and identify valuable nodes and flows which might generate risks. Maybe you should be monitoring them. Maybe you can use IP to control them. And in this sense, IP can also be a tool for business intelligence because you see what other people file. It gives you a feeling for what they think is important. Now, the flow is affected a bit by law, more often by practicalities or by the specific structure of the companies involved. But a very important aspect is contracts that you write or that they have. Next section. How should the executive relate to IP? You look at IP outwards and inwards. In general, the relationship include law, but law is not so much under our control. Behavior of workers and executives, and contract, whether written or not. And as a rule of thumb, any relationship has IP aspects to it, and any contract regulating a relationship should take it into account. Also, any policies. If we look into the company, there probably should be an IP function. Let's call it IP manager. So the most important thing is to have an IP function. The second most important thing is to draw a line between the job of the executive and the job of the IP management. Let me give you an example. If the executive starts discussing the scope of the claims, he's doing the job of the IP management, not the job of the executive. The executive should be saying, I need a claim that company B will take at least $2 million and 2 years to design around. That's the executive's job. And one of the issues is when we draw the line is asking how should we be reporting IP issues from the IP function to the executive. And I'm suggesting not to do it as numbers, not to do it as tables, and definitely not to do it as jargon. Instead, you can talk about the strategy, what effects IP is expected to have, the budget, the goals, optionalities that is created, income, problems, and so on. That's my suggestion. Another very important thing, and I see Efrat on the call, is that the executive needs to set the tone for IP culture, and specifically that IP is important, or not, as you wish. That's facing inwards. Facing outwards, you wield IP, and I believe that is 100% the job of the executive. And usually the executive wields IP together with things that are not IP. This IP function can give advice. And of course, wielding IP is not done in vacuum. You have to know something about your competitors. You have to know something about the market. It's good to have internal information about your competitor, not just what he's selling, but what do they think and what are they doing. Like I said, that's the job of the executive. Going back to inwards facing, I'd like to suggest a concept of IP operating system. Now I'm working on a Windows computer now. Windows is an operating system. I asked ChatGPT, took some prompting, to give me a list of the main jobs of operating systems. And what I've done was shown how it mapped to the operating system, the IP operating system in a company. So one of the big jobs is it allows you to use the capabilities without messing around with things that are too complicated. So, for example, the executive can tell the IP function, I want a license-ready portfolio, without talking to them about what the claims should be and so on. Another one is safety. Want to avoid making mistakes. And again, this IP operating system will prevent things like leaking, activities that kill IP, and so on. Abstractions. The IP function wants to define to the executive what is the language you can use. The IP function does certain things on request, like I need to know what my IP risk is. And it does trade-off control. For example, should we publish or should we patent? Of course, the executive can decide, but if the processes are set up properly, the company will decide. So all of these things are what your IP operating system should do. What is an IP operating system? A combination of culture, habit, the relationship between different processes and functions in the company, policy, procedures, and to have it all be aligned, usually you need some sort of IP strategy and or IP plan. The point is, as an executive, you're responsible for there to be an IP operating system, and you're responsible to use it properly. What does that even mean? Well, part of it is that how you use it depends on the executive's maturity. So we can expect the beginning executive to know less about IP, and as you advance, to know more about IP. So a novice user, he just knows how to tell the IP system, make sure everything's okay. An expert user, they understand much more. Okay, let's pull this lever, pull that lever. And somebody far more advanced, usually not an executive, knows actually had to design an operating system, and in particular design the operating system for a particular company. I mentioned levers. Here's some levers. And you notice none of them talk about patterns. What is the ratio we want to have between different types of IP? And there's lots of definitions of what these types are. How much do we want the IP to support what the company is doing? How much do we want to do attacking IP versus defensive IP? Budgets. There's also levers that aren't directly IP, but still relate to IP. For example, how much cooperation should there be between marketing and IP? It is not easy to enforce cooperation. The executive has to decide how much to have. How aware should workers be of IP issues? As IP, we want everybody to know everything, but again, that has a cost, and the executive has to decide. So until now, we talked about what IP is and how you should look at it and how you should look at it in your company. Now let's see, where does the executive actually touch IP? Whatever you touch is going to change over time. And what you do will depend, we love that word, on context. For example, the market. What is your technological maturity? The competition. They're all changing, and I like using the Nathan, I think framework where you can have clear things, complicated things, complex things, and chaotic things. And usually the world goes in this direction and the company tries to go in the opposite direction. The point is that what you need will change over time, which means your IP operating system will also need to change over time. What is the relationship between IP and non-IP strategy? Well, the general strategy is on top. You have IP strategy and non-IP activities which support it. The non-IP activities should account for IP. The IP strategy will probably need IP, and then you're going to have IP tactics in order to obtain the IP or do all sorts of small things. But it really is telling you that the IP strategy, the company strategy, and the non-IP activities have to be aligned all the time. If you have a good IP operating system, it will handle it, but the executives need to be aware that this alignment over here is important. And of course, different types of executives have different views of what should be aligned and how much it should be aligned and what exactly is IP for them. One of the important things when you do IP is intentional design. So IP can be emergent. You know, invent something, oh my, let's file a patent. But intentional design comes top down, and that's critical. IP design is a process of figuring out what IP your company needs in order to protect itself and do other things it wants to do, and in order to interfere with the competitor. Mapping data and IP flow are also top down and will cause, reconfiguration of the company. Another type of intentional IP is controlling secrets. Okay, you have to think about it and you have to apply a lot of energy to make sure the secrets stay controlled. If we use the word intentional, you can ask, okay, what's your intention? Well, my intention to have happy moments. What's a happy moment? That's when IP saves the day. I had an investment and it worked out because I had a good IP. Now, Intentional IP means also intentionally aligning IP, ongoing, the strategy we mentioned before, but also the timing, the roadmap, the playbook, different types of actions we might want to do in different cases, preparing alternatives, preparing for the worst, sensors which measure different things so we'll know what needs to be done. That's all part of IP design. And they need not only money in the IP budget, they need attention, and they need money which is not in the IP budget, because we expect marketing to report IP, what features are selling and what are the competitors doing. That's work, and work is budget. IP and decision making interact a lot, especially for executives, which a lot of their time is preparing for and making decisions. So IP is an input, and I like saying that every decision you make, you have to consider how does it affect obtaining IP, maintaining IP, avoiding IP risks, and using the IP. But guess what? Also, your competitors take IP into account, and when you make a decision, you should ask yourself, can I interfere with their ability to make decisions? And my recommendation is for the executive to practice identifying IP issues in as many decisions as possible, and it should be done all the time in multiple levels of the company. It says there's something you need to know as well. So IP has some unusual properties. The point is not to understand all of these properties, but to know that they exist and to understand that they can affect you. IP is often national. It's cheap. It uses negative logic. It's not about solving problems, but blocking solutions. It's about the future. It's sensitive. I could add more to the list. The point is that I believe executives should understand these particular properties of IP, which makes them different from more tangible things that they're used to. All through such a course, but perhaps also special sessions, there are some main events that a lot of companies can expect to have and touch points. And some of these are easy to be aware of. Obviously, if I'm launching a new product and launching a new brand, there's IP involved. And some are easy to ignore. So the ones that are easy to ignore should have more examples. It could be useful to organize these examples according to the journey of a company. Another way is taking examples of situations and showing multiple places. I'm doing a contract with somebody. I'm licensing trademarks. We're doing joint R&D together, which will generate patents. We have secrets which we have to use, but we don't want them to know. They have secrets which we don't want to know. Okay, so we have multiple touch points around a particular event. Super important is to learn common mistakes, like publishing before patenting, very common mistake, and learning it from others is wonderful. And when you look at a real case, you can look at the trade-offs that were done between IP issues and non-IP issues and discuss whether this trade-off is a correct one or an incorrect one. And of course, something's happening now. Half of the IP was prepared ahead of time, months or years in advance. This was not strategy. IP strategy deserves the whole course just on that. But in order to understand a little bit about IP strategy, it's important to understand that IP strategy is much more than building a moat. And I think the best way to do that is to give examples of how business strategies used IP in real life. And here's a book, unfortunately in Chinese, with over 100 different cases, not in Chinese, some of them, showing how business strategy used IP. In conclusion, IP is a critically important strategic business tool that a lot of people ignore and underutilize. I want to believe, teaching how IP should be used from the perspective of the person who should be using it, who is not the patent attorney, could be helpful. Unfortunately, most MBA programs don't do that. I talked about some points that are especially important to understand why IP and wielding IP are not the same. When you see a situation where IP and business are misaligned, that's a very strong symptom in a negative sense. Psychology of how people deal with IP could be important. And last but not least, this IP relates to all executives in the company, in all company functions, not just the CTO. So just imagine that you're taking over a new company and it's existing. And the question is, you came in, you have to analyze the company and maybe make changes. As an executive, what IP-related organizational steps should you be taking? I am stopping the recording.